I'm Jeffrey Rosen. I am the president and CEO of the National Constitution Center, and I've been here for about a year and a half, since June 2013. James Madison was passionately devoted to the idea that citizens had an obligation to read laws and read the Constitution so they could contribute to a debate about its meaning and make up their own minds. Yesterday at the Constitution Center, we had a wonderful visit with Chief Judge Robert Katzman, who's written just a great book called Interpreting Statutes. And in that book, Judge Katzman, first of all, makes the provocative claim that Congress intends for judges to read committee reports and legislative history, that administrative agencies rely on this legislative history, and that the claim, which Judge Katzman identifies with Justice Scalia, that judges should ignore this history and instead apply formal canons of interpretation, is explicitly contrary both to Congress's expectations and to Madison's expectations as well. And Katzman quotes Madison worrying about laws becoming too technical so that citizens wouldn't be able to engage and understand them. I think more than ever, in this time of the democratization of public discourse, the best thing about the internet and the video revolution is that we can have conversations like this and all citizens can participate in them. And there's no excuse, if you're a citizen watching this, not to educate yourself about the Constitution. All of the materials are available to you. You can go online. You can go to the, first of all, the best source of all, which is the Constitution Center website, constitutioncenter.org. Listen to our podcast. Go to SCOTUSblog and Fabrizio's great site and watch these videos. But delve into an issue. Of course, the real best thing you can do is read the primary sources. So here's a homework assignment, if you don't mind one from a law professor. Pick a topic that interests you, that the Supreme Court has recently decided or is currently decided. I talked about the Jones GPS case. You can go find it on the Supreme Court website in a second, US v. Jones. Start clicking on the links. You could start by reading the briefs in the case. And if you're not a lawyer, believe me, you don't have to read every word. These briefs are really long. You can skim them and get the basic principles on both sides. Then read the transcripts of the oral argument. We just did a podcast today about the great case involving judicial solicitations for campaign contributions. The oral arguments for that case were online yesterday within an hour after the argument finished. You can read them yourself and make an informed decision about them. Read around the internet about the news coverage of the arguments. Then most importantly, read the decisions once they come down. That's why they're posted online. But read both sides. Often there's a majority opinion and a dissenting opinion. And sometimes there's a concurrence where a justice will agree with the majority but set out his or her separate views. Again, don't be deterred by the footnotes or the legal citations. These are about basic principles. And if you read strategically and with confidence and know when to skim and when to read carefully, you're going to get the gist, the basic principles at issue in each case. Think seriously about the arguments on both sides, and then make up your own mind. And then talk about it with your fellow citizens. One thing I love to do, I don't know what you're going to think about my poor kids for this, but my kids are 8, and we like to have little constitutional debates about the questions you and I have been talking about now, about whether it's NSA surveillance is an unreasonable search, or whether capital punishment is cruel and unusual punishment. And they disagree. They're very different people, and they're extremely articulate, and they have instincts about these things. But we have enough background information that we can have a constitutional debate. And sometimes we change each other's mind. So I just think, first of all, it's incredibly interesting and engaging, and dare I say even fun to be able to participate in these debates. But it's more than fun. It's a duty. The duty is a word we don't use much, but Brandeis used it a lot. He thought that citizenship reached its apogee in the 5th century Athenian polis. His favorite book was called The Greek Polis by Alfred Zimmern, and he thought that the Athenian city-state in which citizens would deliberate about serious questions and reach common decisions was the highest fulfillment of people's faculties. It was men in those days, and thankfully the gender discrimination at the heart of the Greek polis and the original U.S. Constitution has been overcome to some degree by the 19th Amendment. But Brandeis's notion that citizens have not only the right but the duty to educate themselves, to deliberate about constitutional matters, and that in doing so, they develop their faculties. He talked about making people free to develop their faculties. We're not fully human, Brandeis thought. We don't achieve our full potential as citizens unless we better ourselves through education. And I really believe that strongly. I feel so lucky to be able to be part of this educational enterprise, to provide a platform and a forum for this kind of constitutional education. And I'm encouraging you to join me in this great enterprise, educate yourself, and make up your own mind about what the Constitution means. I believe very passionately that there is a meaningful distinction between political arguments and constitutional arguments. When I teach constitutional law, I begin the first day of class by saying, don't assume it's all politics. You can suspect that, you can conclude that on your way home, you can end the class by thinking that. But if you just approach every case thinking judges are just politicians in robes and are just voting their political preferences, you're going to miss everything that's constraining and beautiful and meaningful and distinctive about constitutional law as opposed to political decisions. And here at the National Constitution Center, I really am trying to take this line seriously between constitutional and political arguments. We have a mandate to be nonpartisan. That means we cannot discuss policy issues or have political debates. However, we can discuss any issue as a constitutional debate. So we can't discuss whether gun control is a good or bad idea. You can think whatever you want about that. But we can and must discuss, does the Second Amendment allow or prohibit gun regulations? We wouldn't have a debate about whether NSA surveillance is good or bad, but we absolutely will and have had debates about whether the Fourth Amendment allows or prohibits NSA surveillance. This is a law professor's line, I know, and it's not intuitive, and the truth is that many of my fellow law professors and many citizens are skeptical of this line. And I'm not naive about this line. I am familiar with extensive literature suggesting that there's often a high correlation between judges' political views and their constitutional conclusions. I wrote a book, Unjustly Languishing. I think my mom read it, but it's a really great book. It's called The Most Democratic Branch, How the Courts Serve America. And as you can tell from the thrilling and gripping title, the argument of this book is that basically courts over time have tended to follow the broad currents of public opinion when it comes to constitutional matters. And on the rare occasions when they've tried to thwart deeply felt constitutional views on the part of the public, they've provoked backlashes that have often provoked a judicial retreat. So I not only accept, but have really written a bit about how, in practice, the idea that the courts follow the election returns is true. But that doesn't mean that we can leap from that empirical conclusion to the crude and I think inaccurate idea that there's no meaningful distinction between constitutional politics and constitutional law. We can point to important examples where judges reach constitutional conclusions that differ from their political ones. Justice Scalia often gives the example of how he voted to strike down a law prohibiting flag burning, even though he himself is no supporter of flag burning. He's voted to require the accused to confront their accusers in person because he thinks the confrontation clause requires it, even though he's no fan of accused criminals. And there are plenty of other examples. I think that when Chief Justice Roberts cast his path-breaking and tie-breaking vote in the affordable health care case, he did so because he thought that it was important for citizens to perceive the court as something larger than the political preferences of its members, and he thought it was bad for the court and bad for the country, as he said in interviews, for citizens to perceive 5 Republican judges and 4 Democratic justices and nothing more than that. So the ultimate mixture of law and politics is a complicated question. Empirically, it's worth debating and studying as a scholarly matter, but it doesn't distract me from my passionate and unalterable view that throughout American history, the Supreme Court, at its best, has drawn a meaningful distinction between law and politics. Just look at the inspiring opinion in the cell phone case. 9-0, the Supreme Court, in an opinion written by Chief Justice Roberts, holds that the police need a warrant before they can search our cell phones on arrest because the framers would have expected no less. That's not a decision consistent with the political views of I'm sure many of the justices who are pro-law and order, the liberals as well as the conservatives, I should say, don't like to let suspected criminals free, but they did it because they thought the Constitution requires it, and they believed that that was their duty to uphold the Constitution. So that's what we're going to do at the Constitution Center. We are evangelists for the distinction between law and politics. We are going to encourage and challenge citizens to debate subjects in constitutional and not political terms. And I can assure you, it's a really inspiring thing to do. We had an incredible evening. There's so many exciting evenings here at the center. My head spins and I feel lucky after each one of them. But last year, I guess it was, we had listeners from the local conservative talk radio station in to talk about the Constitution. And the rules of the debate, it was moderated by Chris Stegall, our friend here in Philly. And the rules, Chris said he would ask me any questions. I said they has to be constitutional, not political questions. We all took out our pocket constitutions. Now I'm going to mess up my mic at the end. And debated questions as wonky as whether the president has the constitutional power to raise the debt ceiling under Section 4 of the 14th Amendment. That's a question that law professors have only started to debate, but we read the text of Section 4. I talked a little bit about the Civil War history, and then citizens, most of whom were not lawyers, debated it. And although it was a mostly conservative crowd, we voted before and after, and people changed their mind based on the debate. And some said, I don't like President Obama and don't think he should be able to raise the debt ceiling. But some of them voted, I think he does have that constitutional power, even though I wish he wouldn't use it. And some said, reaches the opposite and thought, you know, I broadly support broad presidential power, but think the president doesn't have it in this case. And after the show, after the debate, a woman came up to me and she said, I am a choreographer. I don't know anything about the Constitution. I'm not a lawyer, but I thought it was my responsibility as a citizen to educate myself enough about this question. And that's why I came here tonight. And I thought, wow, I sure have the best job in the world. This is constitutional heaven. So read the Constitution, educate yourself, and make up your own mind. And thanks to Fabrizio for coming here to the National Constitution Center.